Okay, we'll go ahead and get started now. My name is Jocelyn King. I'm the CEO of Virgil HR. Virgil HR offers a technology that provides instant prescriptive employment and labor law guidance on a variety of scenarios you're working on as an HR professional. So if you have an employee requesting maternity leave and you'd typically be going on Google to figure out what your requirements are, our smart chatbot will analyze what federal, state, and local employment and labor laws that apply to that specific employee, and then provides prescriptive instructions to you on everything you need to do to be compliant. Along with the smart chatbot, we also have a huge resource center, everything from an employee handbook builder to chart making to legal updates. So I definitely suggest you all check it out. I'd like to introduce Jason Plowman. He is an employment attorney at Polsinelli. He and I have been working together for a few years now, and he's amazing. So I'm excited to have you on board. Thank you, Jason. And Tim, our labor and employment attorney here at Virgil HR, who is the brains behind everything our product does, essentially. So excited to have both of you here. I know sometimes you might have to drop off early from the webinar, so I wanted to give anybody an opportunity who is interested in scheduling a demo with Virgil HR to go ahead and scan, and it will take you directly to a Calendly, so you can really quickly schedule some time with me, and I can go through that demo with you, and we'll have that QR code at the very end of the webinar as well. Without further ado, I'm going to jump into the agenda. We're first going to talk about new and upcoming employment and labor law changes in 2024. Obviously, some of them already having gone into effect January 1st. We thought it'd be really interesting to cover some outstanding FLSA and FMLA proposals, and then talk about ways to stay up to date, followed by Q&As with Jason and with Tim. So you can just go ahead and add to the chat any questions you have, and we'll go through those, time permitting, to have Jason and Tim kind of provide some guidance to you all. Speaking of guidance, just a disclaimer that this webinar is supposed to be educational and isn't considered legal advice. You shouldn't make decisions or actions or inactions solely based on webinar content, and should engage with an attorney. That could even be with Polsinelli. So go ahead and feel free to reach out after the fact to Jason. Okay, I'm going to pass it off to the two of you. The areas that we're covering today are minimum wage, leave, joint employment, non-competes, and equal pay.
Thanks, Jocelyn, and thanks to Jocelyn and Tim for having me along. It's always fun to sort of get out of the office and interact with other folks, and still get to talk about what is sort of my bread and butter. At Polsinelli, I co-chair the class actions and collective actions practice group, which means I do lots and lots of wage and hour work. And so you'll see as we go through, I got tagged with most of the wage and hour stuff. So again, as Jocelyn said, if you have questions, put them in the box, and Tim and I will do our best to get to them. So we wanted to lead off with minimum wage changes. Most states, when they do have changes, these happen on 1/1 of the year. From my perspective, it feels like we have a lot of states changing this year compared to other years. In total, we have 22 states, which are marked here on the map, that had increases in minimum wage effective January 1st of this year. It's estimated that this is impacting about 10 million workers. So it's not a small impact at all. And then we have 3 more states that will happen later in 2024. That's Florida, Oregon, and Nevada, that will happen after 1/1 of 24. So at this point, we have 30 states that are higher than the federal minimum wage of $7.25 an hour. The highest is DC, which is at $17 an hour. And as a reminder, if you don't have a state or local minimum wage that's higher than the $7.25, federal minimum wage remains in effect, which has been at that level since 2009. We're going to click through and cover a couple of examples. California, the minimum wage has gone up to $16 an hour. However, we've got several cities, counties, local municipalities that have also changed their minimum wage. And from my perspective, this is really where the rub is keeping up with all the local jurisdictions that have more stringent requirements and making sure you're compliant with all of those. As the slide indicates, we've got more than 40 just in California, and then throughout the country, we've got another more than 40 that are happening at the local level. Here's another example. Maryland is at 15 an hour, but we've got several counties that have higher minimum wages. And here you'll see, between Howard and Montgomery counties, the division is based on the size of the employer. And so that's something you're going to have to be cognizant of. Also be cognizant of industry specific minimum wages. For example, in Iowa, it's totally random, but in Iowa, casino workers have a totally different minimum wage than the rest of the state. And you also see variances at the state level in home health a lot. And so again, make sure that if there's anything sort of unique about your industry, that you're checking that from a minimum wage perspective as well. Again, another example, New York, we've got a state, city, and counties that have different minimum wages here. If you operate in more than one location, you could be subject to multiple different minimum wage levels in a single day. For example, using the home healthcare example, if you've got folks that are traveling in their workday to multiple locations, you're either going to need to figure out how to allocate their time so you're complying with each minimum wage as they move around town, or obviously the easier way would be to pay the highest minimum wage from a consistency perspective. One other reminder in the hospitality industry, if you are taking a tip credit, in other words, you're paying less than the minimum wage and tips are making up the difference, this likely means that your tip credit notices will need to be updated to reflect the correct tip credit that you are claiming. So as a reminder, the tip credit will be the difference between the minimum wage and then the cash rate that you are paying the employee. So if your tip credit notices have a specific dollar amount in there that you are claiming as the tip credit, and the minimum wage has now changed in your jurisdiction, you're likely going to need to update those tip credit notices. And I would also say generally, this is a good time to look at your tip credit notices and make sure that they are compliant with the Fair Labor Standards Act and have all the required information. This is one of the favorite class and collective action lawsuits we get from plaintiffs' lawyers. And it's frankly really low-hanging fruit to ring up an employer for what is really, a technical deficiency in a tip credit notice. With that, I will pass it to Tim to cover leave changes.
Thank you, Jason. Thanks everyone for joining this webinar. So I'm going to go start running through some specific leave laws that have gone into effect or that will go into effect in 2024. Specifically, we're going to talk about some laws in California, Illinois, as well as some local laws in Illinois that are quite important. And then we'll end with a leave law in Colorado. So beginning with California, California's paid sick leave law has been amended. Employees can now use 5 days or 40 hours of paid sick leave per year, whichever is more. So what does whichever is more mean exactly? Well, if an employee works 10-hour days, for example, then the employee would be entitled to use a minimum of 50 hours of paid sick leave. So, so that's something you'll have to pay attention to. This is an increase from the previous iteration of the law, which allowed employees to take 24 hours or 3 days of leave. Eligibility, however, remains the same. The law applies to, employees can take leave if they work in California for 30 or more days. There is a waiting period, which is that employees may begin using paid sick leave beginning on their 90th day of employment. The amount, other changes here, the amount of sick leave an employee can accrue and carry over potentially has also increased up to 80 hours or 10 days. keep in mind that as an employer, you can avoid carryover and employees carryover of accrued but unused sick leave by choosing to front load an employee's sick leave by providing those 5 days or 40 hours upfront each year at the beginning of the year. A final note here on the paid sick leave law in California. If a local ordinance, such as in West Hollywood, Los Angeles, etc., requires an employer to provide more sick leave than the state law requires, then you as the employer must provide that greater amount required by the local ordinance. Moving on to reproductive loss leave. So California already offers bereavement leave upon the death of a family member, and it now requires reproductive loss leave. So, and this applies to employers with 5 or more employees, who must now allow eligible employees to take up to 5 days of unpaid leave following a reproductive loss event. Reproductive loss event in this context means a failed adoption, a failed surrogacy, miscarriage, stillbirth, or an unsuccessful assisted reproduction. To be eligible, employees must have been employed for 30 days prior to the commencement of this leave. Additionally, leave must be taken within 3 months of the reproductive loss event. There's a special rule if an employee experiences multiple reproductive loss events within a 12-month time frame. As an employer, you're not obligated to grant a total amount of leave time in excess of 20 days within a particular 12-month period. So we can move now to the state of Illinois. A lot has happened of late in Illinois. We can begin with the Paid Leave for All Workers Act, which makes Illinois the 3rd state in the country to provide or to pass a law providing employees the ability to take leave for any reason whatsoever. So Illinois joins Nevada and Maine. Again, the employee does not need to provide a reason for leave. They do not need to provide documentation supporting a need for leave. Under the Paid Leave for All Workers Act, employees accrue paid leave at a rate of 1 hour for every 40 hours work, up to 40 hours accrued in a year. There is a waiting period under this law, so employees may begin using leave after their 90th day of employment. Not listed here is something similar, very similar in Cook County, which passed its own paid leave ordinance. It basically mirrors the Paid Leave for All Workers Act, the state law. Employees can accrue up to 40 hours a year. The same waiting period applies, 90 days. And again, employees can use leave for whatever reason they choose. In a little bit, we'll get to Chicago, which has its own paid leave ordinance coming up. But before that, we'll talk about organ donation leave. So in Illinois' Employee Blood Donation Leave Act is now the Employee Blood and Organ Donation Leave Act. Employees can now use up to 10 days of leave in any 12-month period to serve as an organ donor. And so organ in this context, just to be overly specific, includes biological tissue, kidneys, livers, lungs, pancreas, intestines, bone, and skin. And again, so that joins employees' existing entitlements to blood, to leave to serve as a blood donor. We'll go to the Victims Economic Safety and Security Act, VESA, which has been revised for this year. It now incorporates leave for employees related to family or household members killed due to violent crimes. These employees are entitled to 2 weeks of unpaid leave. So VESA has been amended in that way. And under under the amendments, employees can take leave specifically for to attend the funeral or wake of a family or household member who's killed in a crime of violence, to make arrangements necessitated by the death of a family or household member, or thirdly, to grieve the death of a family or household member who's killed in a crime of violence. So again, employees are entitled to 2 weeks of unpaid leave, and that those 2 weeks must be taken within 60 days after the employee receives notice of the death of the victim. We also have the Child Extended Bereavement Leave Act. So this applies to employers with 50 or more employees, who must now provide leave to employees who suffer the loss of a child due to homicide or suicide. Employers with between 50 and 249 full-time employees are required to provide 6 weeks of unpaid leave. Employers with 250 plus full-time employees must provide 12 weeks. Eligibility requirements for an employee under this new act include having to have worked for the employer for at least 2 weeks. And they must take this leave within 1 year from when they notify the employer of their child's death. We can move to the aforementioned Chicago paid leave and paid sick and safe leave ordinance. So the original plan was for this to go into effect at the same time as the state's paid leave law, which would have been January 1st. This has been delayed to July 1st. So under this law, employees can take up to 5 days of paid sick leave, paid sick and safe leave, as well as 5 days of paid leave for any reason at all. There's a 30-day waiting period for employees to begin using leave or sick and safe leave, and a 90-day waiting period for employees to begin using paid leave for any reason, just as under the state law. So we have a note here about certain payout provisions. This is upon the separation of an employee, and whether the employer needs to pay out accrued but unused paid leave. They don't need to do so for accrued but unused sick or safe leave. But for accrued and unused paid leave, which they could use for any reason, employers with 50 or fewer employees do not have to pay this leave out upon an employee separation, but the employer has between 50 and 100 employees. Chicago is allowing these sorts of employers to phase in the payout of earned and unused paid leave. So they can limit the payout to a maximum of 16 hours until the end of this year. And then beginning at the beginning of next year, all employers with 51 or more employees must pay out all earned unused paid leave upon an employee separation. So the Colorado Family and Medical Leave Insurance Act is the last leave law that we'll discuss today. This allows eligible employees to receive up to 12 weeks of paid leave per year. And that could be up to 16 weeks in cases of complicated pregnancies. As an FYI, so this is funded by both employers and employees. The premium is set to 0.9% of the employee's wage. Half of that paid by the employer, half of that paid by the employee. And this will apply to most Colorado employees. They become eligible to take paid leave after earning $2,500 in wages within the state within the last 4 calendar quarters. Employers don't need to be worried. They're not responsible for paying their employees' wages while on leave. The state will pay the employee's portion of their weekly wages directly through a debit card or debit deposit. And now I'm going to kick it back to Jason to talk about the joint employment relationship.
Thanks, Ken. So to put this in perspective, joint employment is a determination that two or more entities share control over a worker's terms and conditions of employment. So there's several agencies and courts that use a variety of standards to decide whether to apply joint employer responsibility under various employment laws. Being deemed a joint employer can obviously create liability under wage and hour laws or federal and state discrimination statutes. The one we're highlighting here is from the National Labor Relations Board. They published a new rule in October of 23, which takes effect at the end of February of this year. And as a reminder, so you don't tune out when you hear National Labor Relations Act, the National Labor Relations Act applies to union and non-union workplaces alike, particularly as it relates to Section 7 rights, which is the right to engage in protected concerted activity regarding terms and conditions of employment. So even if you don't have a union in your workplace, your employees still have certain protections under the Labor Relations Act. So the prior rule had been in effect since 2020. It was relatively employer friendly. To be deemed a joint employer, an entity must possess and exercise substantial, direct, and immediate control over the essential terms and conditions of the employee's employment. Indirect or reserved but unused control was relevant, but it wasn't enough to establish joint employment. So under the new rule, which we've summarized here, joint employers exist when they share or co-determine matters governing the employee's essential terms and conditions of employment. So the National Labor Relations Board will be able to determine that an entity is a joint employer of another entity's employee if it actually exercises direct or indirect control, or simply having direct or indirect authority to control will be enough. Moreover, it's just one of the 7 identified categories of essential terms and conditions of employment. You don't have to be able to control all of those. So the rule doesn't even require that the second entity actually exercise any authority or control. The mere existence of that ability to control under the new rule can be enough. And similar joint employer standards continue to change, not just this one, but as court decisions come down, as agencies change positions with the administration. Many of you probably saw the Department of Labor announced a new independent contractor rule today. Same thing, change of administration. We get, either employer-friendly rules or we get employee-friendly rules. And I'll pass it back to Tim on non-competes now.
Thank you, Jason. So we're going to start in California, where non-competes are now extremely illegal. So not only are they void under state law, but they are now illegal under state law unless they satisfy a few narrow exceptions, which we'll get to in a second. And in addition to being illegal in California, they're illegal regardless of whether the contract was signed and whether the employment was maintained outside of California. Moving to those narrow exceptions, though, you can include a non-compete in situations such as in the sale of a business, dissolution of a partnership, or the termination of interest in a limited liability company. Those will likely be few and far between for most people. An important note is that the law requires employers to notify current and former employees employed after January 1st, whose contracts do include one of those non-compete clauses. So specifically, the notice must be a written, individualized communication, so not simply a mass mailing, and it must be delivered to the current and former employees' last known address and email address. So take special care when crafting non-compete agreements in California. Essentially, We wanted to make you aware of the situation in New York, where there was legislation to essentially ban non-competes, like in California. The governor in New York declined to sign that legislation at the end of this past year. But the possibility of a ban of non-compete agreements in New York is still alive, and employers should be aware of such legislation that might pop up again this year. There was concern on the governor's part that the legislation in front of her was a one-size-fits-all approach. So in new legislation, look out for a salary threshold potentially. The governor and the New York State Senate had discussed exempting workers earning more than $300,000 per year from those non-compete bans. So we just want to put that on your radar moving forward in 2024. And now I will send it back to Jason just to discuss equal pay.
So the equal pay initiatives continue. They're largely at the state level. And if there's any theme here, I would say that it's the regulations and laws are mostly aimed at increased transparency, and also include salary disclosure requirements almost always. So example here, the Colorado Equal Pay for Equal Work Act requires employers to announce, post, or communicate all promotional opportunities to Colorado employees on the same day before making promotion decisions. There's some requirements around remote employees, and frankly, this is where some of the state laws get kind of tricky in terms of who's going to be a remote worker. How sort of broad does your salary disclosure need to go? And employers are also obligated to disclose compensation details and benefits in the job postings under the Colorado law. Hawaii also recently passed a pay transparency bill, went into effect at the beginning of the year, requires employees to disclose in job listings an hourly rate or salary range that reasonably reflects the actual expected compensation for the job. And again, this is complying with this one. It's I would say it's often easier said than done. I've seen some employers that just say the range is going to be $0 to $300,000, which is super not helpful. And I think if you ever got called on it, it's going to be hard to suggest that you were complying with the law in doing that. The Hawaii law also expands the Hawaii's equal pay law. And then another example from the People's Republic of California, which of course takes the cake for creating all sorts of fun laws, but they've now amended the labor code to create a rebuttable presumption in favor of an employee's claim that they've been discriminated against for engaging in certain protected activity regarding wages. So retaliation is also prohibited for various activities regarding wages. And a lot of these activities that are now protected are activities that many employers would consider perfectly fine to regulate, including discussing employees' wages, discussing the wages of others, inquiring about another employee's wages, or helping coworkers in exercising any of those rights. So those are now protected activities under California law that you cannot retaliate against. Some of those obviously are also covered under the National Labor Relations Act already. The other thing is discharging or discriminating or retaliating against any of these, against an employee that engages in any of these are now specifically prohibited. But again, I think one of the interesting things here is this rebuttable presumption that employers, have to overcome if they are defending this type of claim. With that, I'll pass it not to anybody. I will keep talking. Sorry. So in this section, we wanted to cover some things that are just sort of lingering out there. Under the Fair Labor Standards Act, many of you will recall at the end of the end of August of last year, the DOL announced proposed changes to the minimum salary for exemptions under the white collar exemptions. It created quite the flurry of activity in that it would shift the minimum salary from about $36,000 to $55,000. It's estimated that would impact 3.6 million folks. So in other words, that 3.6 million employees would be people that are currently salaried and are somewhere between $35,568 a year and $55,000. So the proposed rule does not include any modifications to the duties test that's required to qualify for any of the white collar exemptions. The proposed rule also increased the salary threshold for the highly compensated employees exception, would increase it to almost $144,000 a year. So the notice and comment period closed at the end of November of last year. I'd be on the lookout for some announcement soon regarding what's going to happen, particularly now that the DOL has the independent contractor piece out of the way. It seems like this would be their focus going forward. It's one thing to keep in mind if you've got folks really close to the 55,000 and you're otherwise going through sort of performance evaluation, compensation adjustments right now, you may want to think about whether you want to, if they're within spitting distance of that threshold, if you want to go ahead and get them over the threshold so you don't have to deal with, a future wage adjustment that may be possible. The other thing I'd point out is we've got 6 states out there: Alaska, California, shockingly, Colorado, Maine, New York, Washington. These states all have minimum salary requirements for overtime exemption that both exceed the current federal level, and they all also increased in January of this year. So for example, Washington State is all the way up to $67,724 a year in order to qualify for overtime exemptions. And under Washington law, it's scaled to increase every consecutive year.
Okay, and I'm going to discuss a few outstanding proposals concerning the Family and Medical Leave Act. Now, these were introduced at the beginning of last year, so it's hard to say exactly what sort of momentum they have, but we wanted to put it out there for everyone to take a look, regardless. So the first is the Job Protection Act. So currently, as we know, employees are eligible for leave under the FMLA if they work for an employer with 50 or more employees, have worked for at least 12 months, at least 1,250 hours over the past 12 months prior to requesting leave, and where they work at a location where the company employs 50 or more employees within a 75-mile radius. So those are the eligibility requirements. Currently, the Job Protection Act would make some changes. It would reduce the length of service requirement from 12 months to 90 days and would essentially make that the new eligibility requirement overall. It would eliminate the worksite requirement and the 1,250 hours of service requirement, and would essentially eliminate the employee threshold for employer coverage, taking it from 50 employees, which it currently is, all the way down to 1 or more employees. The second outstanding proposal is the Caring for All Families Act. So the FMLA's current serious health condition coverage allows employees to take leave to care for their own serious health conditions or that of a spouse or a child or a parent. Under the Caring for All Families Act, that would be expanded. It would include or permit leave to care for a domestic partner, parent-in-law, adult child, or another related individual who has a serious health condition. It would also introduce other family care needs. as a new element of FMLA coverage. That includes leave such as parental involvement and family wellness leave to participate in their children's and grandchildren's educational extracurricular activities. So again, those are introduced at the beginning of last year. We'll have to keep an eye on them throughout this year to see what sort of traction they get in Congress.
Okay, thank you both. All right, so really quickly, ways to stay up to date. Obviously, these are changing all the time. As Jason just mentioned, even the IC ruling, the independent contractor ruling, coming out and going to effect in March is just another example of how often these laws change. So this does get very difficult and quite burdensome for HR professionals and business owners. So one thing we'd suggest is subscribing to email alerts like through organizations like SHRM, keeping abreast of these employment laws via blogs or websites. And we would really encourage you to check out polsinelliatwork.com. Polsinelli is a really amazing law firm that's nationwide or maybe even global, Jason. I'm not sure, you'll have to correct me on that. But the blog is really informational, and I'd highly encourage people to take a look at it. And then, of course, taking a look at our technology to help you stay up to date with these changes. Not only are we providing legal updates on all laws that are changing at a federal, state, and local level across the country, but we also offer a compliance calendar that helps you organize all of those effective dates so that you're well aware by state or locality when these changes are happening, and you can prepare and adjust your best practices or policies, of which we give you new policy templates as well. So we're going to go ahead and move to Q&A. If you have any questions, please submit them in the Q&A section. Will these slides be sent out following the call? We won't be sending out the slides, but we will within the week be sending out a recording of this webinar. Next question, are these updated laws already updated in your system for us to review? Yes, we send out legal updates automatically once we hear about these changes, and you can find that in your announcements section, but we also send out a summary of all of the changes by week every Thursday to your email. What you will see though is if you're working with the chatbot and there isn't a law that it goes into effect until July 1st, you're not going to see those changes pop up until July 1st because we want to make sure that you're using the most up-to-date information, if that makes sense. Yes, the presentation has been pre-approved by SHRM. We weren't able to get a code from them, and I'm not sure why. I think there's some troubleshooting issues on their website. But if you look us up as a certification or a continuing education provider, or you put in the name of this webinar, 2024 Employment and Labor Law Updates, you'll be able to get 1 hour of SHRM credit. Unfortunately, it's not HRCI approved. We didn't go through the application process with HRCI, but we will for future webinars. Anything else? Okay, so here's some contact information. Please feel free to reach out to me, Jason as well, if you're interested in using their law firm services too. Feel free to schedule a demo. We are doing another webinar January 17th, and that's going to be about HR audits and HR strategy review to prepare for 2024. Please take a look at our LinkedIn page and go ahead and register for it if you're interested in joining. We have a really great panel joining us. And that's it. Thank you all very much for your time. Thank you, Jason and Tim.